Okay, we should be good now. Hello everyone, good morning, welcome. I'm Leonard French, your favorite copyright attorney, here with the next Sunday episode of Lawful Masses. And I think we're all good here. Let's get some feedback on the audio. I seem to be peaking a little bit here. And maybe turn that down a bit. There we go, that might be a bit better. Good morning, everyone. Good afternoon, good evening, and good tomorrow for the few of you that are stuck in Monday already. I really wish you could be with us here in Sunday, but Monday will have to do. I will bring the music down a little bit. Oh, that's not even the music, that's why. I pressed the button on the wrong music. Oh well, we'll let this one finish. Alright, there we go. Yeah, there's a little bit of clipping. I have a compressor on. You know what, I can take it to where it was on the other stream where everybody said it was great. So how about that? This should be a lot better. We'll turn off the music eventually. Alright everybody, good morning, good morning, good morning. We have a bunch of cool stories to talk about today. And then, like I said, we'll kill the music for the actual stories, so just put up with me for a moment, I appreciate it. We're going to talk about the Aquila, obviously, versus Sargon of Akkad lawsuit. There's been some movement there. I'm going to remind you to go watch one of my videos. Epic Games has sued yet another cheater, and it's a pretty good one. So go check out that video. Meanwhile, there's an update in YouTube demonetization. So we've had the whole adpocalypse and stuff going on, and I've had 5 of the last 6 videos demonetized, and they're all remonetized after manual review. But geez, that's a real that's a bummer, man. That's just a real bummer, man. And so YouTube, I'm in the middle of yelling at them, and apparently they released some kind of an update to the ad demonetization bot, or the video demonetization bot. So we're going to take a quick look at that. You may remember a few months ago, Bill Browder, who is a international financier investor person. He is one of the, if not the largest foreign investor in Russia, or he was until he discovered that Vladimir Putin was taking a lot of money illegally, and so were a whole bunch of the Russian wealthy oligarchs, I'll call them. And he testified to Congress about how Vladimir Putin managed to coerce and threaten and actually act on some of those threats and get these people to pay him half of the corrupt money in Russia, making him allegedly the wealthiest man in the world, wealthiest person in the world. And, well, Bill Browder, of course, has now turned into an anti-corruption investigator, advocate person who goes and talks to our Congress and others around the world to help further his anti-corruption agenda, which I'm totally on board with. So what does Russia do? This is the 3rd time they have placed him on an Interpol watch list and gotten his visa revoked and asked authorities to arrest him on Russian charges that don't really exist or would be trumped up anyway. No pun intended. And so we're going to go over that situation. More copyright-related stories. Judge Jed Rakoff of the Southern District of New York has issued a fair use ruling. There was a defendant who was making children's books, and the children's books were making very, very heavy use of other children's books. And so we'll go over what made that not a fair use. I'm going to cover, I know we're in danger of getting demonetized for this one, but I'm going to cover the story where a pharmaceutical company's founder has been criminally charged with a racketeering scheme to distribute opioids, drugs, illegally. You know, if you don't know, we're having a crisis in the United States where many thousands of people are getting addicted to heroin or opium-related substances. Many times it starts by getting pain medication for an actual ailment, and then the doctor or system not making sure that the person stops taking opioids once they're done with their recovery. And there are ways that people can find, either through the system or illegally on the street, find drugs that are available. And now we have this added problem of a stronger drug called fentanyl, which is several tens of times more powerful than heroin, and people can't tell the difference when they obtain it illegally, and so they go and take this fentanyl thinking it's their regular grade heroin, and they find themselves quite overdosed. And the treatment for said overdose is a fairly expensive drug called Narcan. And so this just creates a very tumultuous spectrum of real problems with real consequences, and what are the societal solutions to those. And of course you have politicians getting involved as well. So here we have some actual real charges showing that pharmaceutical company here in this case is literally doing some of this terrible work of spreading opioids to people who don't need it, in the hopes of making more money and not really caring about the consequences. Then we have two interesting stories. I recently found out that Nintendo changed the terms of their creator program, and they are no longer allowing live streams. So we're going to talk about that. You cannot live stream your Mario Odyssey or whatever on YouTube or Twitch or really anywhere else. All you can do is a offline, edited, then sent for approval sort of that's sort of a edited video thing. Anyway, hey, why don't we kill the music now? Oh yes, and before I forget, there is an update in the Purple Mattress case. So we'll go over the preliminary injunction that was issued. The judge made a bunch of rulings. So this is going to be a sort of interesting, complicated, long live stream, and we're going to power through some of this stuff, trying not to take 20 minutes or 30 minutes per topic, or we'll be here all day. So thank you all for joining me, and I think we're going to get started. Let's pull up the Sargon of Akkad case. Oh, also I'm going to be giving Brandon a few seconds between stories, because we're going to try and make use of the highlight system and release some of these as videos after the stream, so that you can go back and watch. If you couldn't join us, or if you had to leave, or if you simply can't sit through a 2-hour live stream, because you know these things become that. If you simply can't sit through a 2-hour live stream, then you can go back and watch some of these stories there. And maybe it'll be a good experiment with the demonetization bot as well. We'll see if it's one or all or none of these videos get demonetized. So let's pull this up here. This is a fairly quick story. That's not it. Firefox is misbehaving again. 1 second. We're going to start this story over. There we go. Okay, so here we have an interesting story in the Hughes versus Benjamin case. This is the Akilah Hughes versus Carl Benjamin case in the Southern District of New York. What we have here is a default has been entered against Carl Benjamin, aka Sargon of Akkad. So default is what happens when you don't respond to the lawsuit. And let's see what it looks like here. I, Ruby Krajcik, clerk of the United States District Court for the Southern District of New York, do hereby certify that this action was commenced on August 25th with the filing of a summons and complaint. A copy, etc., was served on defendant, personally served by Federal Express. You may remember that a couple years ago, or actually was it a couple years ago or was it a couple months ago? I forget. It was very, 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 very recently There was a ruling in the U.S. that said that that service by mail was okay internationally as long as international law provided for it. We didn't used to have that sort of clarity on whether you could serve somebody by mail. So here we've confirmed that they have served Carl Benjamin by Federal Express by mail. Proof of service served September 8th. And if he hasn't responded, then they've entered default. So what does default mean? Well, default is that that Federal Rule of Civil Procedure 55A. Oh, that's not it. FRCP 55A. And all it really means is that default has been entered. Note that this section does not say anything about default judgment. That's part B here. So all we're talking about is a default, a failure to respond. Now Morrison and Lee will go back and make their claim for damages and show that to the court. And as long as the court doesn't think there's anything wrong with that, then that default judgment will get entered against Sargon, and then they'll have the next step of trying to figure out how to get that executed on him in his home country. I believe that's either England or UK. I'm not sure what the legal observation is there. Who you sue where internationally is a very complicated topic that I'm not ready for at this time. So that's a very interesting story. We'll keep an eye on that, and when there's some kind of movement on the damages, we'll have an update, or I'll do a video or bring it up on a live stream.
People are saying that there was a purple mattress ad?
You're getting a purple mattress ad right now? Oh, that's cool. Well, maybe we move that story up then. No, you have to understand, Purple Mattress has been very generous to me. They are not actively sponsoring me, people. So I don't think I have a duty to disclose that I get paid by Purple Mattress or anything, because we don't have that kind of active relationship. However, I will disclose that in the past they've given me money in the form of those ads that you saw running before the video. I have nothing to do with that. I just make the video and enable monetization, but they queue up on the keywords, I believe, and run an ad, and I do get a portion of that. So it's not that I'm in advance sponsored by them, but I do realize that they like my video on their thing, and they've paid me money for that. So full disclosure, I recognize that, and when this ruling came down, I wanted to share this with you because both I think you'll find it interesting, and maybe Purple will run more ads on my videos too. I'm not ashamed of this. This is fine with me. I hope it's fine with you too. We all need to get paid and keep this thing going, especially with YouTube's continued demonetization of everything. My revenue is down significantly in October. And that's fine. I'll be fine. I just have to plan to not be getting a normal size check in November. And that's fine. And this is why I really love all of you Patreon supporters, because you really are the thing that's keeping this going. When I can't count on YouTube's income to get me through the next month, I can count on you guys. And that's really a real blessing, and I really appreciate that. But enough pandering, and let's get to the freaking story. So, what do we have here? We have an order on a preliminary injunction, and I've apparently messed up my filters. Oh, here we go. We're gonna fix this real quick, and then we're gonna start the story over for the thing. This is Adobe, and the filter. Yeah, why is that doing that? That's weird. I'll just do this. There we go. I'll just do this. Transform center. There we go. Okay, that'll work. This is much better. And so we're going to start this over real quick. So there's been an update in the Purple Mattress case. The judge issued a preliminary injunction. Now, this is document 191 in the case. I apologize. I have not read the other 189 or 87 or whatever. We read a couple in one of the in one of the stories. We went over the complaint and I think some of the responses. So we've gone over a couple of these documents. I honestly did not go through all of this. I think this document here will summarize a lot of what's happened. So this is Purple Innovation LLC, which is the Purple Mattress Company, versus Honest Mattress Reviews, Ryan Monahan, and Ghostbed. And this is by the Honorable D. Benson of the United States District Court for the District of Utah, Central Division. On May 24th, Purple Innovation, Purple Mattress, submitted its motion for a preliminary injunction against Honest Mattress Reviews, Ryan Monahan, and Ghostbed. After full briefing, the court held an evidentiary hearing, having carefully considered the motion, the evidence, the arguments, the submissions, and for good cause the appearance. The court now enters the following findings of fact, conclusions of law, and order. On March 2nd, the court entered a TRO against defendants requiring, among other things, that certain online articles and statements posted by Monahan and HMR on the Honest Mattress Reviews website be taken down. On March 15th, the court granted the Monahan defendant's motion to dissolve the TRO and denied Purple's motion to convert the TRO into a preliminary injunction. If you've been following the Imagos case, some of this may be familiar to you, why we're on a TRO or a preliminary injunction. I'm going to skip that part here. It's not really relevant to this. Purple subsequently filed the instant motion, again seeking a preliminary injunction. Purple submitted the declaration of Kalisha Anderson, a former employee of Ghostbed, in further support of the motion. Following a hearing, the court set evidentiary hearing. The court held an evidentiary hearing. The court heard testimony from Monahan, Werner, and Anderson. And the court has made determinations on the credibility. The court found the testimony of Kalisha Anderson to be credible and persuasive as to the relationship between Ryan Monahan and Ghostbed. If you recall, there was a review of the Purple Mattress that was not favorable. It's fine, right? But it brought up really odd questions about the white powder, and it seemed a little bit hyperbolic, but arguably somebody could be really upset about the white powder. And this was posted on Ryan Monahan's honestmattressreviews.com website and subsequently attacked by Purple Mattress as being fraudulent, so misrepresentative that there's something more going on here. And so that's what we're trying to find out here, is what is the more going on. Even without Anderson's testimony, the evidence in record and presented at the hearing is sufficient to demonstrate the existence of a clear affiliation between Monahan and Ghostbed. In contrast to Anderson's testimony, the court found the testimony of Monahan and Werner to be less than credible. In any event, their testimony did not convince the court that no substantial relationship exists between Monahan and Ghostbed. Based on the testimony of Anderson and the documentary evidence presented at the hearing, the court finds the declarations of Werner and Monahan submitted in support of their motion to dissolve the TRO to be very concerning. Certain statements in the declaration, including Werner's statement in paragraph 12 that Ghostbed does not have any affiliation whatsoever with Mr. Monahan, are at best misleading, if not outright false. Subsequent paragraphs in Werner's declaration fail to elucidate the details of the relationship between Monahan and Werner in a forthcoming manner, and the declaration is, in many respects, misleading, oblique, and likely the product of careful attorney drafting. The evidence also strongly calls into question the veracity of Monahan and Werner in the declarations to the effect that Monahan's use of the title Chief Brand Officer for Ghostbed was unauthorized and a mistake. Monahan acquired the domain name Honest Mattress Reviews on or about August 10, 2016. Monahan registered the domain name through Domains by Proxy, which conceals the actual name of the owner. At about the same time, Monahan created the HMR social media, including but not limited to YouTube, Facebook, Twitter, Instagram. Since its inception, Monahan simultaneously posts to them, sole owner, etc. As discussed below, Monahan and Ghostbed have an affiliation that dates back to at least 2015, including an economic relationship. Despite Monahan's close association with Ghostbed, the Monahan defendants fail to disclose anything about the association on the HMR website or social media. The disclosure on the HMR website that Monahan consults for many companies in this space, as well as other industries at various capacities, does not adequately disclose Monahan's relationship with Ghostbed. Shortly after, or simultaneously with Monahan's launch of the HMR website and social media, Monahan and Ghostbed engaged in efforts to remove evidence of their connections from the web. Among other things, Monahan removed the Chief Brand Officer title from his LinkedIn and Twitter profiles, and Ghostbed changed the author of various articles on the blog page of its website from Monahan to Sleep Team. The court finds defendants engaged in these efforts purposefully to hide from the public the affiliation between Monahan and Ghostbed. Beginning in 2015, Monahan provided extensive digital marketing and social media services to Ghostbed. Monahan provided these services on an ongoing basis through his company Social Media Sharks, which acted as a subcontractor for Achieve Agency. Ghostbed paid Achieve for its services on a monthly basis. Ghostbed through Achieve has paid Social Media Sharks approximately $150,000. Based on Monahan's testimony, however, it appears that certain invoices may not have been produced, which means the amount may be larger. Ghostbed currently pays Social Media Sharks $10,000 per month for the services it provides to Ghostbed through Achieve. Monahan continues to provide digital marketing and social media services to Ghostbed through Social Media Sharks and Achieve to this day. Among other things, Monahan has been and is in charge of Ghostbed's Facebook page. He has assisted with the design and content of the Ghostbed website, and he has worked on sales promotions and marketing emails sent to Ghostbed customers. Monahan has worked on competitive advertising for Ghostbed, including an advertising targeted at Purple, one of Ghostbed's primary competitors. On at least one occasion, Monahan contacted Werner to request permission to run an attack ad on Purple and target Purple users on Ghostbed's behalf. Monahan, with Ghostbed's knowledge and consent, at times represented himself as Chief Brand Officer of Ghostbed. Monahan, with Ghostbed's knowledge and consent, used a ghostbed.com email address. The Monahan defendants' statements about Purple. Defendants' honest reviews and Ryan Monahan posts about Ghostbed on the HMR website have been very favorable. Indeed, it appears that one of the very first, if not the very first, mattress review posted on the HMR website was a review of the Ghostbed, which received over 4 stars. By contrast, the statements and articles on the HMR website and social media have been extremely critical of Purple. The Monahan defendants, with Ghostbed's knowledge and consent, have targeted Purple on the HMR website and social media with a negative and inflammatory online campaign regarding the anti-tack powder that Purple uses on its mattresses and pillows. Among other things, the articles and posts about the anti-tack powder state and imply a false and misleading in a false and misleading fashion that the powder is dangerous and causes cancer and respiratory problems, including for persons with asthma. The articles and posts about the anti-tack powder state and imply a false and misleading fashion that Purple is trying to deceive or hide facts related to the anti-tack powder from consumers. The Monahan defendants' articles, posts, and videos have gone viral and have spread widely throughout the web, such that Purple's use of the anti-tack powder is now a common topic in various online fora. The proper plural of forum. Wow, cool. Additionally, the Monahan defendants' commentary on the lawsuits has spread widely throughout the web, including the YouTube video published April 11th, the Purple Mattress Sues Me Over These 4 Safety Questions video. Monahan has pinned the Purple video to the start of the HMR Facebook page, where it has been shared 4,000 times and generated 1,200 comments. HMR's YouTube channel, where Monahan has pinned the Purple video to the beginning of its homepage, indicates that nearly 3.5 million users have watched this video. As reported by consumers to Purple's customer service department and on various online platforms, including the HMR website and social media, and including Purple's website and social media, the statements and assertions in the articles and the related materials are causing consumer confusion. Numerous consumers are questioning the safety of Purple's products, and many consumers affirmatively believe that Purple's products are in fact dangerous, cause cancer, and cause respiratory problems. The Monahan defendant's statement and assertions have impacted consumers' purchasing decisions, causing them to return Purple products, decide not to purchase products, and cancel their orders on Purple products. Werner admitted that in May 2016, his daughter, Ashley Werner, who is employed by Ghostbed, posted a false review of the Purple mattress on Amazon.com under the fictional name Cami J, in which she implied that the Purple mattress uses the same powder at issue in lawsuits involving Johnson & Johnson, and makes reference to all these people getting cancer from their powders. The Monahan defendants have made similar statements on the HMR website and social media, suggesting that Purple's anti-tack powder is baby powder or talc, such as that involved in the Johnson & Johnson lawsuits. Ghostbed's customer service representatives have made false and misleading statements to customers to the effect that Purple uses baby powder in its products, and that Purple's products cause cancer, and that Purple's products cause people to cough up blood. Ghostbed has not denied that the statements are false, and according to Werner, Ghostbed has told its employees to cease making all such statements. As a result of the statements on the HMR website and social media, the false review on Amazon, and Ghostbed's false statements to consumers, Purple has suffered irreparable harm, and it faces the prospect of continuing irreparable harm to its reputation and goodwill. As a result of the online campaign against Purple, Purple has suffered lost sales in an amount that may be difficult to quantify. Conclusions. Plaintiff has a substantial likelihood of prevailing on the merits and its claims against defendants, and there are serious issues of merit of those claims that merit further litigation, including in particular plaintiff's claim for false advertising. The evidence shows that Purple is substantially likely to establish that a strong connection and affiliation exists between Monahan and Ghostbed, which relationship is not disclosed on the HMR website or social media, that statements made on the HMR website and social media regarding Purple and its products and its services are false and misleading. 3, that the omitted disclosures regarding the Monahan-Ghostbed relationship and the negative statements about Purple are material and are impacting consumers' purchasing decisions. 4, that the statements and omissions are made in commerce. 5, the omissions are as to the Monahan Ghostbed relationship are likely to cause confusion and mistake and to deceive as to their affiliation. The false and misleading statements regarding Purple and its products and services are made in commercial advertising and promotion. The false and misleading statements and its products and services misrepresent the nature, characteristics, and qualities of Purple's goods, services, and that Purple is suffering damage as a result. Unless a preliminary injunction issues, plaintiff will continue to suffer irreparable harm. An injunction would not be adverse to public interest. The threatened injury outweighs any harm that might result to defendants, and therefore the preliminary injunction shall issue. And the order goes like this. This order binds and is enforceable against defendants and their officers, agents, servants, employees, and attorneys. The Monahan defendants shall immediately and prominently display on the Honest Mattress Review's website and all associated social media platforms, including without limitation the Facebook, YouTube, Twitter pages. They should display the disclosure statement below. The disclosure statement must be clear and conspicuous and must appear at the top of the pages. The disclosure statement shall read as follows. The owner of HMR, Ryan Monahan, has previously held himself out to the public and the court as independent and unbiased. However, the Federal District Court has found that Monahan has a significant business relationship with Ghostbed and its CEO, Mark Werner, from which Monahan derives significant income. The court also found that HMR has been consistently favorable to Ghostbed and unfairly critical of Purple's products, one of Ghostbed's primary competitors. For more information, go to this link. The Monahan defendants shall immediately remove and delete all online content previously published by them that include any statements or inferences to the effect that Purple uses baby or talc powder, that Purple is affiliated with Johnson & Johnson, that Purple's products cause cancer, that Purple's products cause people to cough up blood. Such content shall be removed from all websites, social media, and any other location. Prohibited from reposting. Shall clearly and conspicuously display the disclosure statement. The defendants are prohibited from publishing or making statements related to the lawsuit, etc., etc. Ghostbed shall not make any statements to the effect that Purple uses baby or talc powder, and Ghostbed shall remove from its website and social media all references to HMR as an independent third-party mattress review site. Very, very interesting. What do you think of that? I believe I have here the Honest Mattress Reviews website. I think we might have actually typed over it. Honest Mattress Reviews. And if we go here, you can see they have it right here at the top. The district court entered an injunction requiring the above disclaimer. They've appealed the injunction, and here's the disclaimer. The owner of HMR, Ryan Monahan, etc. And then they provide a link to the injunction. So he's going to appeal the injunction, but it sounds like the judge ain't got no time for that. It really, really sounds like the judge has found some things about Honest Mattress Reviews to be completely false and untrue, and the judge is definitely concerned for irreparable harm, hurting Purple Mattress in all of this. So I actually feel a little bad for Purple Mattress. This sounds like they really did, like Ryan Monahan really did conspire with Ghostbed to make a not so honest review site that's literally titled Honest Reviews. Like how much worse can you get with this? It's literally freaking titled Honest Reviews, and yet he wasn't so honest about being affiliated with Ghostbed and conducting this viral attack marketing campaign without disclosing his relationship with the competitor. So that's really interesting and a little bit sad, because we live in this wonderful society where we're supposed to work hard and innovate and make our money based on the merits of what we do, not this backdoor, surreptitious, false and misleading and confusing stuff that's meant to take advantage of consumers' inability, because frankly it's part of the human condition. Consumers just can't look into everything. Like, they can't do this level of research for everything. It's unreasonable to expect that. So they're taking advantage of that by being misleading and hoping that people will not be able to look into their statements and will simply act upon their statements. Doesn't that happen to us all? So very interesting story. I look forward to hearing your comments and questions on that. Brandon, if you want to post a link in the chat for some questions, I'd be happy to take some questions on that. And then we can start the next story. Brandon, you're muted or something.
Honest Mattress Reviews is in our chat. It says he sent you a link to something that you need to read.
Okay, I'll be happy to read it. We'll go over that probably for the next stream.
Cool.
I'll definitely read it before I make a new video on the subject. That's fine. But yeah, this judge does not like the relationship between Ghostbed and Honest Mattress Reviews and Ryan Monahan. So next, I thought maybe we'd go over this. What do we think? YouTube is fighting the adpocalypse. You know, the adpocalypse itself, the part that I'm upset about is not the part where advertisers left YouTube because some outsiders did some kind of, hit piece. Like, okay, I get it. That happens. The response is what I'm upset about, that their response is to simply blanket demonetize videos without telling anyone why and letting us deal with the consequences. It feels very much like they've made it clear how important the advertisers are and how not so important the creators of the videos that the advertisers go on are. Does that make sense? So I'm a little upset with YouTube right now, and I'm going to try to refrain from being too harsh, but it seems to me like all of the transparency we just talked about in the Honest Mattress Reviews case is also a problem here. Why is YouTube not being more transparent? Is there something that they're hiding? Or what's going on? So I'm not I'm not entirely sure, but what I can say is that of the last 6 videos that I've made, 5 of them have been demonetized by the ad bot. And the funniest part to me is that there was one video in there where I cursed a lot, and that would have been the video I would have expected to be demonetized. No, that wasn't the video that was demonetized. No, it was the videos after that where I actually tried real hard to not trigger the bot that 5 out of 6 videos got demonetized. Now, I can just trigger a manual review. What's the big deal? It's a big deal because the demonetization also triggers some other things. Your video doesn't get promoted on YouTube within the normal channels. I don't expect YouTube to promote every video, but I do expect them to promote them in the normal way. But if you get demonetized, then you're not getting promoted in the normal way. So whereas videos in the past have started off with this large hump of the initial hype period, it's a much smaller hump now, and then it quickly falls off to 0 the moment you get demonetized, and then there's no chance of recovery when you get remonetized. It isn't like YouTube tries to pay it back by promoting the video that they realize they mistakenly demonetized. I honestly think they should be doing something like that. Am I going to sue them over it, though? No. There's a reason for that. One, you don't poop where you eat, and I had to think about that for a second, so I didn't use the curse word. You don't poop where you eat, and you also, this is a contract. Like, I can go to a different website. YouTube is its own private entity, so I'm not entirely sure that I can sue YouTube for some kind of unfair trade practice or something. I know people have. We have two actually lawsuits now. One of the things we're going to talk about this week is that Prager University has also sued YouTube over the adpocalypse, claiming that they're making talking head videos like I do. They make them on their topics, and Prager University is right-wing. I'm not saying anything bad about right-wing. I actually watched a few of their videos, and they don't seem to be bad videos. They don't seem to be calling for anything strange or weird or extreme or violent, or they don't seem to be violating YouTube's policies. They just seem to be slightly politically charged videos. And even for politically charged videos, they are not bad for today's political climate. They're definitely not using some of the more extreme hyperbole that I see in today's political climate. So they really shouldn't be demonetized, other than maybe like the normal advertisers can go in and say, I don't want my videos appearing on political videos, or I don't want my advertisements appearing on left-wing videos or right-wing videos. That I could understand, but they're getting completely demonetized, and so they have also filed a lawsuit, and they very carefully show all of the different videos that are not demonetized, the videos that are covering the same topics in a similar way that are not demonetized, but their videos got demonetized. So it does sort of seem at first glance like there's some sort of discrimination going on there that's not, it's not entirely fair discrimination. So that's what I'm concerned about here, is that by YouTube using a simple Bayesian AI to, and those are separate things. It's not, Bayesian is not really an AI, but using a simple learning algorithm to determine which videos should be flagged or not. And I'm assuming something in there has to have some sort of AI that identifies. So maybe the AI is the thing that's identifying what's in the video and the keywords and things, and then the Bayesian algorithm is trying to decide what's good and what's bad. And it doesn't work that way, guys. This should be a little bit. This should be reachable by such intelligent people. either that, or it's really just a big screw you to the community, and they just don't care to put in the time and effort to make it better, or don't put in the time and effort to explaining to us that they don't know. Instead, they want to continue to appear like they know exactly what they're doing, and if they it's one or the other, right? They either know exactly what they're doing and they are screwing us on purpose because they don't want to deal with this any other way, or they don't know what they're doing while they're lying to us about having everything under control. So it's kind of a shitty situation. I'm kind of ticked off about it, and I hope that this story here, that they've rolled out some kind of new algorithm that more accurately reflects their guidelines, that 30% of videos will be remonetized, many automatically and retroactively, not retroactively monetarily, just they're going to be remonetized even without your input, some of them. I'm hoping that this is the beginning of a proper system that's... Because what else are we going to do? I'm looking into streaming on Twitch instead, but Twitch is a gaming platform, and I'm not entirely sure they're ready for non-gaming content, but we'll look into that. And we'll look into other opportunities. Maybe I can partner up with some larger organization that will produce an actual show as opposed to a YouTube-only show. Maybe an actual produced show that gets released to platforms, or... Maybe we still release to YouTube, but we're produced through a different... These are all changes I don't want to have to think about. I want to create these videos for you, and I don't want to have to think about, oh, well, how is my hard work going to get invalidated by the demonetization bot today? That's not something I want to wake up in the morning and think about. I want to think about what's the news today, what do my viewers want to watch and hear about, and I want to put all of my time and effort into creating videos instead of fighting my own platform's bot that they put in place to demonetize me so they don't have to check their own guidelines themselves. It's really lazy, right? On one hand, I get it that they can't check 400 hours of video that's uploaded every minute or day or something like... I think it's every minute. It's uploaded every minute. I get that. But at the same time, like, you're making statements that I've violated your policies when I haven't violated your policies. And it's now 5 times you've said that I violated your policies when I haven't violated your policies. At some point, this gets to be too much, right? So that's an interesting one. What do you think of that? Would definitely love to hear your comments and such on that. Let me take a moment now to thank the contributors who have been super chatting. I am on the wrong... That's the wrong page. This is the right page. Thank you very much to Peter McAninch. Peter McAninch. It's going to take me a moment. Thank you, Peter, for the $5. You're up early for the live stream. Well, thank you very much. Stephen Wilson, thank you for the Canadian 10. Not much to see, lots of time. Stop, reverse that, thank you. Also, count on the tipping wars. Canadians are best. I don't know, my Norwegian friends and Finnish friends might not be here starting the tipping war yet. Janos Pastor gives €5. Twitch is fine with non-gaming content in the creative section. They confirmed a while ago. Okay, we'll definitely try releasing some things to Twitch and see how we do. I think it's a different monetization system, so I have to learn a whole different system of how that works. So here is our next story on Bill Browder. You may remember Bill Browder was a person who testified before Congress back in July or August, and I made a video about it because it was kind of an important topic. He testified. He's an investor or a financier. He's a very wealthy individual, and he seems to be a kind of stand-up guy. I would like to be able to just jump on board, but let's just say that from what I've seen, he seems like a really stand-up guy. He's fighting corruption in Russia. Now how that came about may make a little more sense. He was investing in Russia. He was trying to profit from Russia's progress coming out of the Soviet Union and the rather large depressing area the rather large, long depressing era that happened after they came out of the Soviet Union. And so Russia is now some kind of representative democracy. I forget what it looks like, but it's really an oligarchy. It's really a governmental system that's being run by the wealthy individuals of Russia. Well, Vladimir Putin, a former KGB agent, some might say current KGB agent, Vladimir Putin, at some point found himself with enough power to challenge these oligarchs and literally arrested one of them and threw him in a cage in the middle of a courtroom and convicted him handily, and then turned to the rest and said, hey guys, I want half. And so he got half. He controls half of the corrupt money in Russia, arguably making him the richest person in the world. Well, Bill Browder was this poor guy who's not poor, but he's definitely been treated poorly. And he comes in, he's investing in Russia, and he's getting along with Putin, and he's noticing the Russian oligarchs and the corrupt money, and he's losing money, many double-digit percentage points, 30, 40, 50% of his investments he's seeing hits as high as that in corruption and things like that. So he opens his own investigation, and he hires his own attorney, Sergei Magnitsky, to investigate. And while he's conducting this investigation, Sergei Magnitsky, I forget it, did he shoot himself in the head twice? Is that what it was? Was that the one? Sergei Magnitsky committed suicide in a very non-suicidal way, but it was ruled as suicide. You know how this works? I'm seriously not that big a conspiracy theorist. This is a real story. So Sergei Magnitsky commits suicide, but it's not suicide, and the investigation on our end uncovers this, and a law was made, sanctions were put in place called the Magnitsky Act. Let me see if I can figure out if I could spell. The Magnitsky Act, formerly known as the Russia and Moldova-Jackson-Vanik Repeal and Sergei Magnitsky Rule of Law Accountability Act of 2012, is a bipartisan bill passed by Congress, signed by President Obama, intending to punish Russian officials responsible for the death of Russian tax accountant, Russian tax accountant Sergei Magnitsky in a Moscow prison in 2009. Sergei Magnitsky died after investigating fraud involving Russian tax officials. So Bill Browder comes to U.S. Congress and testifies about all of this. And you can go watch his testimony. It is a video. It is online. I did a story about it, and then you can actually go watch his video. It is kind of it is gripping to watch him testify about this. And he's in the middle of doing all this. He's conducting his investigation. He's now an anti-corruption advocate, and he's doing all of this. And so doesn't Russia go ahead and put him on Interpol's Red Notice watch list, which is the list they put you on to have you picked up by international authorities without a warrant? And they managed to get his travel visa revoked for a few hours, at least for about 24 hours, until the situation was resolved by Interpol. And Interpol has now had to issue a statement to its member nations to ignore Russia's attempts to arrest Bill Browder, because it's obviously a corrupt attempt to involve someone who's investigating them. Jesus! What the heck, people? I mean, could you be more obvious? So, guys, when we talk about the Russians, please don't assume that the Russians are our friends now. There are definitely Russian people who are friendly, and I love the Russian culture very much. I love the Russian people very much, but the Russian authorities are some of the most corrupt. The Russian mafia is some of the most active. Really really, really let's be a little bit more skeptical about Russia in the future, because some of this stuff is really happening, and it's a bit concerning. What do you think of that, everyone? Love to hear what you think about Russia, including, this is an international show. It's not unlikely that I have some Russians watching my show, and I would love to hear what you think about this from the inside as well. Do we have it right? Does it seem, is someone making all this up, or is this seems to be a real thing, seems to be corroborated several times over? And Putin wasn't like coming into power or something like after this. Putin's been in power for a very long time. Somebody can tell me
something like 20 or
how
30
long.
years, right?
1999, I think it says here.
Yeah.
Prime Minister in 1999, and then President. So he's been in power since 1999. And what is it, 2017? So that's 18 years, 19 years so far that he is in power. And that's, whew, I'm glad we have term limits on our presidents. Even the ones we like, I'm glad that we have term limits on them. So what do you think of that? Please send your questions to Brandon via the link that he'll post in the chat. And why don't we take a break real quick, since we're almost at an hour here? Why don't we ask some of our questions?
Sure, give me a second. Delay.
We have 3 more stories to go over. Also, I've been trying to accommodate the highlights reel, so
Yeah.
let me know if I'm making any mistakes there. Or I can do
No,
it
you're
myself.
good. That's why I'm asking you to delay, though.
Also, this is root beer. This is not alcohol. I know it's a big thing on YouTube. I'm not supposed to be drinking alcohol on stream, so. Don't want to get demonetized for 2 seconds of a bottle being on stream.
Delay.
Some people think that Browder's version of events is a little bit sensationalized. Others are reminding us that most governments have some kind of corruption. I think that's a good assumption, is that we should assume that people in power are susceptible to corruption, and rather than always treating them like they're corrupt, maybe we should just put the checks and balances in place like we do, and enforce those checks and balances to make sure that corruption just has its normal check. You can get demonetized for drinking alcohol on stream or video. I'm not sure how often it happens, but at this point, having 5 videos be demonetized out of 6, when for doing what I consider absolutely nothing to violate the policy, at this point we're looking for things, and this is where Google engineers may need to look to science and Heisenberg. And you may know that Heisenberg's uncertainty principle says that, oversimplified, we change a system by observing it. You cannot observe a system without either taking or providing energy to that system. So you can't observe, say, in Heisenberg principle's case, you can't observe both the spin and charge and motion or position of an electron or particle or atom or whatever, all at the same time. You might be able to determine how fast it's moving, but you won't be able to determine its temperature or its spin. Someone can maybe give me a better description for the stream, but the point is, you observe a system, you change it. So telling people that there is a demonetization bot and that you'd better be in line with the guidelines is one thing. Having the demonetization bot go so wildly wrong that people now are going to change their behavior by changing their titles and changing their video, trying to fool the bot and that's counterproductive and is going to add layers to things that I think Google needs to account for. And I don't see anything in any of their materials that they've communicated to us that they are accounting for the fact that we are now having to change our titles and change the way we make videos and things to accommodate the bot that is not working properly. That's another reason why I'm ticked off at YouTube about it. And instead of them having a conversation and saying, yes, we know it's tough and we're going to help accommodate you by doing X, they just say, well, this is how it works and you're going to have to do a manual review. Well, if your system is that broken, then you should be doing the manual reviews on your own. But of course you can't, because I understand, 400 hours every minute and all that. But still, if your system's that broken, then you need to fix it, not us. We aren't the ones that broke it. I didn't do anything to break your system, so why am I the one having to fix it? Sorry.
I'm good now, by the way. Sorry. I do have some questions for you if you like.
Yes, go ahead.
We are a little frustrated with this demonetization thing. Like, honestly, it's very frustrating. When I saw...
And it makes me then have to come to you and go like, oh, could you guys please support me more on Patreon? Could you please send I hate asking you for more money. The point of this whole thing is that you give me what you can, and YouTube gives me what whatever from... And that's apparently something that's allowed to be played with, and that bothers me that they play with the income of their creators so
frivolously,
yeah, exactly, frivolously, wantonly, recklessly. Recklessly is the word I'm looking for. If the other thing that article confirms is that they only just updated the demonetization bot, even though it's been running for almost 3 months. It wasn't learning actively. It was learning and cataloging its learning or something, and then they implemented the learning yesterday or Friday. What? Really? We had to put up with 3 months of no movement so that you could do like a one-time thing? Why wasn't it learning as it's going like you said it was? I don't know. I just feel like YouTube's lying to us, and we just have to suffer through it or leave the platform. I mean, part of me really wants to go find these companies that pulled this shit, and not buy their products ever again. Like, I already don't drink Coca-Cola. That wasn't that Coke and Pepsi, didn't they pull their ads because of the stupid adpocalypse thing? I want to go find this list, and I want to make sure that everybody on YouTube who's a creator knows this list of companies that have treated us like this and have forced YouTube to do this. And I'm still hating on YouTube for having kowtowed to this. This is dumb. Just because Ugg Boots tells you, and I'm just making a story here, I'm not saying that Ugg Boots pulled their advertisements, but why would we listen to Coca-Cola or Ugg Boots or Pepsi, or who cares? We let us create the beautiful community that we've created. Look at how many of you are here studying law and learning about current events and things, and YouTube wants to shut this down without telling me what I've violated? Sorry, getting on my soapbox again.
Want me to ask some questions?
Go for it. Let's hear some questions.
Rosemary Seal Pop asks, if a video of yours gets demonetized and monetization is restored on appeal, does the income from views that occur in the demonetized period get paid to you, or does YouTube pocket it?
Neither, if I understand correctly. The ads don't run, so neither YouTube nor I get any income for those views that occurred during the demonetization period. When the video is remonetized, ads resume, and then both of us split the advertising revenue, 55 to me and 45 to YouTube, I believe.
Yeah, and the thing is that the demonetization often occurs at the most important time for our monetization. So, like, it's when we're getting the most views that they demonetize it. And that's the part that hurts the most, is that all of these views that we get at this perfect time, they don't get monetized, and so the creators get hurt so much. Like, it's all well and good that they remonetize our video a day or two later, but like, that's not when the video is being watched the most. I can show you,
that's exactly right.
I can show you tons of graphs on our channel that show that it falls off after about 16 to 18 hours, for most videos, not all of them. Obviously some of the Alex Maurer ones are different, but
And that's fine. And we get monetization for the first hour or 2 or 3, and then it gets demonetized during the major hump, and then it gets remonetized after the major hump and when we're into the long tail. So a video, and also let's not forget that the demonetization drops promotion as well, the normal promotion on YouTube's browse and search features. So not only do we get we don't get any money for the views, we don't get any viral traction. That's another problem, is I could make the most viral video you've ever seen, but if it got demonetized, it wouldn't get seen enough to go viral. So now I'm being encouraged to what? Screw around with my viewership so I can try remaking and re-uploading videos so that the ones that get demonetized I can just delete, and you guys get to see 3 notifications or 4 notifications for the same video in slightly different formats so that I can try and fool the What bullshit is this? Why do I have to change my creative pursuits to suit YouTube? I'm doing something that's well within their guidelines. I shouldn't have to further mess around with my format to accommodate their guidelines that I'm already following without feedback, without them telling me what guidelines the bot said I didn't meet. It won't even tell me that the bot said that it found a curse word, or that it found whether it was the bottle, or whether it didn't like the word abuse, or it didn't like the word law. They don't even tell you the bot didn't like the word lawsuit. They don't even tell you that.
Here's the thing that's golden. You ready for this? Are you ready? You might be a little pissed off. The Purple Mattress case review update that I just created, 19 minutes and 8 seconds long, just got demonetized. The highlight of this live stream from 20 minutes ago just got me demonetized. Yes.
Oh my god. Oh, Jesus Christ.
And I've noticed it's because I watched it. It's because I opened it. The other ones I haven't opened, they haven't been demonetized.
Purple Mattress case update already demonetized.
Yep. So that's 7 now? Or 5?
That's 7 out of 8.
Yeah, that's... Oh my god. Honestly.
At least we have it as marked as private.
Yeah, we still have it marked as private. So that's the other thing. Why are ads playing on private videos? Whatever. Never mind.
Well, no, this is I've heard that this is one way to do it. Oh, and thank you for everything you did there. I've heard this is one way to do it, to make the videos private and then let it demonetize and then trigger the manual review immediately.
All right, so while you're doing your next story, I'll go into the other videos and watch them, like get a view on them, see if they get demonetized, see what happens.
Yeah, so you guys were on the stream for this. I didn't curse. I specifically avoided cursing. The title is Purple Mattress Case Update. So what about this is in any way outside of YouTube's policy? In any way? Whoa. I mean, I'm getting to the point where I want to file my lawsuit so I can get some answers in discovery.
Honestly.
I'm getting really so ticked off about this because I have bent over backwards to accommodate their guidelines and policies, and they continue to say that I violate their policies.
And cheers to the first time we've ever gotten an update on a case that we covered during the show. So that's cool.
It's Bill Browder, by the way.
I'll fix that. Ben Browder is the man who played Cameron Mitchell in Stargate SG-1.
And I'm just going to grab a screenshot of this.
Tweet it out.
Review requested.
Yeah, honestly.
I'll tweet it out after.
Yeah.
Let's see. This is a Purple Mattress. That's funny because Purple Mattress is the one that's been monetized. Like, YouTube literally promoted my last Purple Mattress video, and this time I am talking about the extra promotion. That video has gotten an extra 100,000+ views because YouTube put it into their browse features.
Maybe it is because masses has asses in it. Maybe that's the answer here.
But even when I don't put masses in the title and stuff. Viennicus says, Google, considering how Google responded to its internal sexist memo, the adpocalypse doesn't surprise me anymore. I'm noticing a pattern. Yeah, it's like they're overly PC compliant, overly politically correct compliant. Thank you, Engine Fair, for the Norwegian kroner.
Oh yeah, the doggos.
Too few doggos, yes. I don't have dog B-roll this week. I can throw some old dog B-roll up, or I can drag the dogs in at some point.
All right, maybe we should move on to the next question.
Next question.
Um,
Don't want to kill the stream by the whole demonetization
yeah,
thing.
it's just really frustrating, is all.
Very frustrating.
Yeah, Jay Zeno asks, what process would Purple go through to figure out actual damages? How do they compute the cost in money?
They might be able to show sales figures from a previous year or previous period, and then be able to show a drop off after the Ryan Monahan ghost bed honest mattress reviews things happened. If it may be very expensive, they may have to hire a expert accountant who is an expert in assessing damages in cases like this. And from my experience, I'm going to say in the smallest of cases that I've ever done with companies worth $500,000 or less, that accountant wants $15,000 to do that analysis. And in a case like Purple Mattress, I'm assuming they're going to want more like $50,000 or $100,000. Maybe 35. You could get a deal, $35,000 for that accountant. I'm going to guess it's going to be extraordinarily expensive to assess the damages, because someone's going to have to dig through all the sales records, correlate them with dates and times that things happened, and make arguments. Meanwhile, Ryan Monahan, Ghostbed, HMR are doing the same thing for the opposite reason, trying to minimize that number and attack every reason that the plaintiff gives for assessing damages. So it's going to be an interesting back and forth, and you might see if HMR and the defendants and such feel like they're going to lose the case, they might just settle the case and it might end quickly. I don't know what the status of that is. The preliminary injunction we just saw was from earlier in September, I think, later in September, and so I'm not sure what the movement is on the case right now. I don't think there was anything quite... There were a lot of sealed documents and things after this, so I don't know what the status of the case is right now. It does appear that Honest Mattress Reviews and Ryan Monahan are appealing the preliminary injunction, so I can't say that it's fact yet. We have to wait for it to be unappealable before we can say that these things are true, for sure. But that's what the judge said. What we read was what the judge said. We'll see where it goes from there. More questions?
Yes, sir. Next up is from Paul Cuts UK. He's asking that if he records a video game footage that has a person in it, i.e. in multiplayer, what would his requirements be in regards to that? So if they're using game comms or something like that, could the person that is recorded, could they stop that from happening? I mean, do they have a copyright in
sort
that?
of. They don't have a copyright. They might have an expectation of privacy. So this topic changes. The law changes depending upon where you are. The law is different in the EU, is different in Russia, is different in Massachusetts, is different in Connecticut, is different in Pennsylvania, is different in California. Whether a person has a reasonable expectation of privacy and what the consequences of that are will be in some kind of state law or country's law. And whether a Discord chat like you and I are in now is a place where you have a reasonable expectation of privacy is not something that's very clear. So let me give you some easy guidelines while also telling you that this is not your legal advice for your state or area. You should probably tell people any place where they think they might be in private that you're going to do something public, or that they are public, or that you're streaming or something like that. If you go into a Discord chat that is open to the public, that's arguably not a place where you have a reasonable expectation of privacy. But you can create a private call between two people, private video conference or a private call, or even a locked room or something like that. So if enough of those facts come together, a judge and jury might agree that a person had a reasonable expectation of privacy in that forum, in that public forum or private forum. For example, a car inside a car with the windows closed and you're talking and everything, that might have a reasonable expectation of privacy. So if you have a dash cam, you need to know whether you're allowed to record audio. If someone has a reasonable expectation of privacy that the law recognizes, then you need to tell them and disclose if you are recording or streaming or anything like that. If not, it's still probably pretty good courtesy to let them know that you're streaming or recording, because that's, they might change what they say. They might suddenly blurt out, about that rash they had on their butt or something, and maybe they don't want to tell the whole world about that. I don't know, but that gives somebody a chance to then basically be responsible for their own words and what they say, and everybody knows, and that way you don't accidentally have somebody say something that they would never have said on stream. That said, these laws apply to real life as well, so you can't just go around recording people in private in real life either, because of these same laws, these expectations of privacy. Now, if a person has committed a crime and you're trying to catch them in the act and whatever, I would recommend you work with your authorities on that one, because if you have permission from your police or you've obtained a warrant through the police and through the judge, then maybe you will be asked to make a recorded phone call or something and try to get the person to admit what they've done wrong. So these are complicated things, and I definitely recommend you look up your local laws before you try and record anyone or stream anything with other people on it without their knowledge. It'd just be easier if you just tell everybody that you're streaming and recording, and make sure that they either have a chance to consent or leave before you actually broadcast their voice or their image.
All right, Crimson J sends in, Dear Leonard, you are living proof that not all lawyers are cut from the same cloth. What things should someone look for when trying to find a lawyer or attorney to take a case?
That's a difficult question, but I'll try to answer it. Lawyers, first off, we're in the 21st century, and there are a lot of lawyers who realize that the old bedside manner of attorneys is not a really good way to interact with customers and clients anymore. So you will have an easier time these days finding someone who will be nice to work with, I think. That said, it's still kind of a journey. If you've ever had to find a doctor or a really any kind of professional to do something difficult that you can't do, you know that there are some good ones and there are some bad ones, and there are lots in between. So what you really want to do is look for a lawyer that has experience. I'm not trying to say anything bad against new lawyers who don't have experience, but from a customer's standpoint, one of the things that you can look at most reliably is that a lawyer has experience, and that experience has not generated any disciplinary action or major complaints from clients that you find online. Certainly, you can expect to see a complaint or two about an attorney because of just the nature of the law. Even when people win, sometimes they're not happy. And sometimes clients expect lawyers to work magic, and that doesn't happen either. So definitely check out their reviews online, check out the status of their license, and try to find out about their experience. Make sure they have experience in the area of law that you want to hire them for. Or if you really want to try and get through something as cheaply as possible, you can also try to hire somebody who's outside of those guidelines. As long as you know that someone who has less experience might need a little bit more time to figure things out, or might make a mistake or something. As long as you're okay with that, you can go outside of those guidelines. But generally, I would say check their experience, check their record, and check their reviews. Some things to watch out for: a lot of attorneys will require payment up front before they will do any work. This part is normal, but they should at least have some kind of consultation with you, even if it's for a small fee. You probably shouldn't be working with an attorney who requires a $5,000 payment before they'll even talk to you. But there are some of those out there, and I'm not saying they're bad or good. That's just something to be concerned about. Look first for their reputation and reviews and such first before you pay a large amount of money without. Make sure that you can get your money back then if you're going to pay a large amount of money just for a consultation. I wouldn't recommend having to pay like a retainer fee just to consult with someone. So maybe have a lower cost consultation. Excuse me.
Makes sense.
Should creators buy media liability policies? I have one that covers defense costs, very expensive. Yes, the policies are expensive because the risk is high and the costs of the defense are high. It really depends. That's a really tough question. You may need to talk to an attorney to figure that out, because I don't know what your channel is creating and how, and if you are using lots of licensed material, maybe you do want a media liability policy just in case you forget or miss a license on one of the things. If you're doing what I do with a bunch of talking head stuff, and I could probably defend myself in court, I don't have a media liability policy, but that's definitely something to consider if I start using anything, using others' material regularly, or especially if I'm skirting the edges. If I know that I'm using material that might not be a fair use, then I would definitely consider making sure that your policy covers that too. You got an ad during the stream. That's interesting. It wasn't me. I did not click insert an ad over here, but that's interesting.
Strange.
Other questions, or I'll move on to our next story, the big story.
We do have one more. Do you want me to ask it?
Go for it.
Are there from Salem Adams? Are there legal issues if YouTube runs ads but withholds the money under a manual review for 1 month, or whatever comes first?
Yeah, if YouTube held the money, there would be bigger legal issues. I'm assuming one of the only reasons they're able to get away with this is that no one's getting the money. Like, YouTube's not getting the money, the advertiser's not getting an advertisement. They're just not running the ads. So, wow, so it's very interesting. Some of you have gotten ads on the stream that a highlight already got demonetized from.
Yeah.
This is just like conflict. This is contrary stuff. Like, how can they say that my clip is not ad friendly, but the whole live stream is?
That doesn't make any sense.
This doesn't make any sense whatsoever.
Okay. Well, okay then. Ready for the next story?
Yeah, I'm going to start the next story now. We'll do the couple second pause. So our next story, coming out of the Southern District of New York, a bunch of publishers, Penguin, Random House, Simon & Schuster, Truman Capote, Jack Kerouac, Hemingway, Arthur C. Clarke, have sued Frederick Colting and Melissa Medina, doing business as Moppet Books. And Judge Jed S. Rakoff, who I think is a pretty famous judge who has done one or two things with, I forget, maybe Brandon can look that up for the end of this, has ruled that what they're doing with these books is not a fair use. And so I thought we would go over his opinion here, and we'll see why. On January 19th, plaintiffs, all of them, alleged 9 counts of copyright infringement against Frederick Colting and Melissa Medina. Plaintiffs are owners of the exclusive licenses to copyrights in 4 famous novels: Breakfast at Tiffany's, Old Man and the Sea, On the Road, and 2001: A Space Odyssey. Defendants have published a series of illustrated children's books based on these novels, called The Guides, which contain condensed, simplified versions of their plots. So I'm going to compare it to Cliff Notes. Thrift Notes? Where did that come from? To Cliff Notes. I don't know how similar they are to Cliff Notes, but let's just assume that these were unlicensed, condensed, simplified versions similar to Cliff Notes. Following the completion of discovery, plaintiff sought summary judgment. In a bottom line order dated July 28th, the court granted summary judgments on all 9 counts, 2 for each of the 4 novels and 1 for the character of Holly Golightly, and rejected the affirmative defense of fair use as a matter of law. On the issue of willfulness, the court permitted defendants, based on representations made by their counsel, to raise defenses and additional discovery on that defense. As a consequence of that decision, plaintiffs no longer seek summary judgment on the issue of willfulness, and the court has set the case down for trial to resolve the remaining issues. This order sets forth the reasons. The pertinent facts, either undisputed or were disputed and taken most favorably to the respective non-movement, are as follows. Plaintiffs own valid copyrights to Breakfast at Tiffany's, Old Man in the Sea, On the Road, and 2001, A Space Odyssey. The defendants' colorfully illustrated story summaries called Kinderguides are designed to introduce these works to children. On or about September 22, 2016, defendants published their 4 guides. On their front covers, the guides very prominently display the titles of plaintiffs' novels and the names of their authors, along with the words Kinderguides in large print. Early Learning Guides to Culture Classics in smaller print. The only other words are illustrations by blank, containing the name of the author in small print at the bottom. The guides share the same layout. The first 4 pages feature illustrations and one-line quotations taken from and attributed to the authors of the novels. The 5th page contains publication information. The 6th is a title page. Kinderguides, Early Learning Guides to Culture Classics, On the Road by Jack Kerouac. Illustrations by Rose Forshall. A division of Moppet Books, Los Angeles, California. The 6th and 8th pages contain a table of contents. The 9 is an illustration of the original author. The 10th is a page about the author. The following these are short summaries which comprise a few dozen pages. Appended after these short summaries are a series of back pages, 2 devoted to main characters, keywords, quiz questions, and analyses. Defendants admit that they had access to plaintiffs' novels in preparing their guides. This is part of copyright law, that you have access and that your work was substantially similar. Indeed, a side-by-side comparison of the plaintiffs' and defendants' works reveals as much. Not only do the plot, settings, characters of the guides mirror the novels, but the guides include many specific details. For example, Holly Golightly's business card reads, Holly Golightly Traveling. And in both versions, Holly describes an experience she calls the mean reds, or feeling afraid, but you don't know of what you're afraid. He goes on to quote further. It is also undisputed that there is an established market for children's books based on adult novels, and that it is not unusual for copyright holders to publish or license children's versions of works originally intended for adults. Noting that defendant Colting understood, prior to publishing the Kinderguides, that there was a market for children's editions of adult novels. Defendants, however, never sought permission to prepare children's guides for plaintiffs' novels. It is further undisputed that plaintiffs have never authorized anyone to publish children's versions of their novels. The managers of Hemingway's literary estate altogether rejected requests to create children's versions of The Old Man in the Sea. Penguin is considering a version of 2001, but is currently against it. Capote Estate did authorize an illustrated standalone version of A Christmas Memory, but did not authorize Breakfast at Tiffany's. Finally, Penguin, Random House, and the Clark Estate have authorized the creation of English as a second language version of 2001, but no children's versions. When parties cross-move for summary judgment, the court analyzes the motions separately, in each case construing the evidence in the light most favorable to the non-moving party. Summary judgment is appropriate only if the moving party shows there is no genuine issue of material fact and that the moving party is entitled to judgment as a matter of law. The court must draw all reasonable inferences and resolve all ambiguities in favor of the non-moving party. The Copyright Act of 1976 grants copyright owners a bundle of exclusive rights, including the right to reproduce, to prepare derivative works. Plaintiffs allege that defendants' guide infringes on both of these rights. To prevail, plaintiffs must prove that they own a valid copyright, that defendants have either actually copied their works, and that defendants' copying is illegal because of a substantial similarity between defendants' works and the protectable elements of their copyrighted work. To prevail on the second ground, plaintiffs must prove that defendants' works are unauthorized derivatives. I'm going to skip the valid ownership part. I'm assuming that they have a valid copyright. Having therefore carried their burden with respect to ownership, plaintiffs must next show their work was actually copied. They can show this by direct evidence or by indirect evidence, including access to the copyrighted work and substantial similarity. The question of actual copying is distinct from and precedes the question of infringement and substantial similarity. To prove actual copying, however, plaintiffs need only show probative similarity, that the creators of the allegedly infringing works drew from the copyrighted works. Here, the undisputed facts easily establish actual copying. Defendants admit that in preparing their guides, they read plaintiffs' novels. They display the actual titles of plaintiffs' novels on the front of their guides and concede that their guides are based on the novels. This constitutes actual copying as a matter of law. It would be absurd to suggest that actual copying did not occur in a case where defendants' work is devoted to telling a large portion of the story of plaintiffs' work. Substantial similarity. I'm going to skip this because we want to get to the fair use part. To avoid, therefore, this obvious similarity, defendants would have the court, in effect, subtract the defendants' guides the characters, plots, and setting that were directly lifted from plaintiffs' novels on the ground that these elements do not constitute protectable expression, noting that a court must limit its infringement inquiry to whether the protectable elements standing alone are substantially similar. Defendants make several arguments in support of this approach. First, defendants claim that the characters, plots, and settings in plaintiffs' novels are merely a collection of made-up facts or fictional facts, and since, historically or independently, facts are not protected, these elements are not as an aspect of an author's original expression. Are you kidding me? You're really trying to say that a work of fiction is rather a collection of made-up facts that does not warrant copyright protection? I'm sorry, I've seen some BS. That's pretty big BS. As defendants put it, their guide to 2001: A Space Odyssey merely summarized the facts of the book and the characters, not the creative expression that makes Dr. David Bowman and Hal, the characters, memorable. Defendants, in other words, the aspect of plaintiffs' novels appear in defendants' guides, such that the character of Holly Golightly, her place of residence, her trips to the prison, her relationship with Sally Tomato, are not protected expression, but according to defendants, fictional facts. This exercise in sophistry, however, which confuses the difference between historical or independently existing facts and fictional details created by a novelist, finds no support in applicable law. As the Second Circuit has clearly stated, characters and events that spring from the imagination of authors are copyrightable creative expression. I really can't believe the judge has to go over this. Thus, the Copyright Act protects the literal text describing, for example, Dr. Bowman and Hal and the made-up facts about Dr. Bowman and Hal. Quote, unlike the facts in a phone book, which do not owe their origin to an act of authorship, each fact in defendant's guide is really a fictitious expression created by plaintiff's authors. Wow.
You forgot to change your scene, Leonard.
That's okay. We will change the scene now. Second, defendants argue that the characters in plaintiffs' works are unprotectable stock characters, for example. Breakfast at Tiffany's is, according to the defendants, just the story of a small-town girl with a tough past who has come to the big city. Dean in On the Road is just a stereotypical womanizing wild guy, and Sal, our narrator, is portrayed as a young writer. Thus, defendants argue Sal and Dean are simply stock characters that do not warrant copyright protection. Defendants again misstate the law. While copyright law does not protect basic characters and stock figures, copyright law does protect characters who are sufficiently delineated to be original. As the Seventh Circuit points out, in the very case defendants cite, a knowledgeable old wino is not a copyrightable character per se, but one named Cogliostro with an obviously phony title of Count and faintly mosaic facial features is protected. No more is required for a character copyright. Finding that Wonder Woman, a superhero with only superficial differences from Superman, is infringing, even though both are drawn from the same basic Herculean character type. Excuse me, not Wonder Woman. I misread. Wonder Man. Wonder Man, a superhero with only superficial differences from Superman, is infringing, even though both are drawn from the basic Herculean character type. The general rule is that where defendants' works use more than general types and ideas and have appropriated the pictorial and literary details, works are infringing. Here, defendants do not even attempt to conceal their copying. Third, defendants argue in the latter regard that the plots of plaintiffs' novels, which defendants reproduce in their guides, are unprotectable scènes à faire, or incidents, characters, or settings which are, as a practical matter, indispensable or at least standard in the treatment of a given topic. So, for example, you can't copyright talking head videos. You can copyright a talking head video in which you did other stuff, but you can't copyright the concept of talking head videos. Or, for example, defendants argue that The Old Man and the Sea is a classic man versus nature story for which a trip in nature, the struggle against the fish, reflecting on nature, triumph, and defeat are unprotected. 2001, defendants say, is simply a man versus technology plot. On defendants' absurd theory, the plot of Don Quixote is simply Cervantes' hackneyed version of the Odyssey. Defendants totally ignore the well-developed distinction that while general plot ideas are not copyrightable, specific ones are. Defendants' guides do not tell stories that share similar plot elements with plaintiffs' works. They retell, in an abridged fashion, the very same stories, including the very same characters, incidents, settings, and plot twists as the original novels. To be sure, they do not copy every single incident, but it is well established that no plagiarist can excuse the wrong by showing how much of his work he did not pirate. Nor need a work create the same feel or effect as the copyrighted work to be infringing. By any reasonable comparison, defendants' guides copy substantial aspects of the themes, characters, plots, sequencing, pace, and settings of plaintiffs' novels. Indeed, that is their stated purpose. And derivative works. Plaintiffs also allege that defendants' guides violate their right to control the preparation of derivative works. The Copyright Act defines a derivative work as a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work is not derivative, however, simply because it is based on the pre-existing works. Only works that are recast, transformed, or adapted into another medium, mode, or language while still representing the original work are derivative. For example, book reviews and parodies are not derivative despite being based on and potentially reproducing substantial amounts of protected expression. That's a great sentence. That's Campbell v. A. Cuff-Rose Music, one of the famous copyright cases from the Supreme Court, 1994. That case stated the general rule that the market for potential derivative uses includes only those that creators of original works would, in general, develop or license others to develop. So they wouldn't license someone to make a critical work, or in general would not license. So that does not count as a derivative work, even though it is based upon. Depending on its nature, a guide may or may not qualify as a derivative work. The issue turns on whether the guide changes the copyrighted material in such a way that the guide is no longer representing the original work of authorship. For example, the Second Circuit found that a guide to the TV show Twin Peaks, which merely transformed the original work from one medium to another, was a derivative work, but an encyclopedia based on the Harry Potter world, which did not tell the same story, was not a derivative work. By condensing, synthesizing, and reorganize the pre-existing material in an A to Z reference guide, the lexicon does not recast the material in another medium to retell the story of Harry Potter, but instead gives the copyrighted material another purpose. That purpose is to give the reader a ready understanding of individual elements in the elaborate world of Harry Potter that appear in voluminous and diverse sources. Here, though defendants' guides add additional material at the end, specifically a few brief pages of analysis and quiz questions, and information about the author, they are primarily dedicated to retelling plaintiffs' stories. 2 pages of analysis do not convert the guides overall, which are largely composed of story summaries, into something that no longer represents the original work of authorship. Like a translation, dramatization, or motion picture adaptation, defendants' works basically retell the story of plaintiffs' works in another medium. Because defendants never received permission from plaintiffs to produce their guides, the guides are unauthorized derivatives as a matter of law. And finally, to fair use. Defendants argue that, even if they have infringed plaintiffs' novels, defendants' guides are protected by the doctrine of fair use. Fair use is an affirmative defense to infringement traditionally defined as a privilege in others than... I don't like this sentence, but traditionally defined as a privilege in others than the owner of the copyright to use the copyrighted material in a reasonable manner without his consent. I prefer to see fair use as a right from the Ninth Circuit's case. Was it Ninth Circuit? Shit. In Lentz v. Universal. Though a fair use is a mixed question of law and fact, where a court finds no genuine issues of material fact, it may conclude as a matter of law that the challenged use does not qualify for fair use protection. The mere fact that a determination of the fair use question requires an examination of the specific facts of each case does not necessarily mean that each case involving fair use, there are factual issues to be tried. The Copyright Act specifically specifies 4 non-exclusive factors that bear on fair use. 1, the purpose and character of the use. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market for or value of the copyrighted work. These factors are not meant to be treated in isolation. They are designed to be weighed together. The doctrine of fair use furthers these goals by permitting others to use existing works in ways that their owners would not ordinarily use them. What fair use law does not protect is the right of others to produce works that, generally speaking, the creators of imaginative works might choose to produce themselves. Congress granted the exclusive right to produce or license such derivatives and others substantially similar works to copyright holders, regardless of whether, in any given instance, the copyright holders intended to use these rights or not. The central question presented in this case, then, is whether illustrated children's guides to adult novels are the sort of use that Congress reserved to copyright holders, or the sort of use, like criticism or parody, which Congress intended to allow others to exploit. The first factor in a fair use inquiry is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. The work that adds further purposes or different character, altering the fact with new expression, meaning, or message, is often described in case law as transformative. Transformation in this sense has a particular meaning. As Judge Laval explains it, a work is transformative if it is productive, if it adds new insights and new understandings, seeks out new life and new civilizations, and boldly goes where if it adds new insights and understandings for the enrichment of society. Transformative uses of a copyright work may include, for example, criticizing the work, exposing the character of the original author, proving a fact, or summarizing an idea argued in the original in order to defend or rebut it. Here, defendants argue that their guides are potentially transformative in 3 respects. They abridge plaintiffs' novels, they modify plaintiffs' novels for a younger audience, and they add to plaintiffs' novels a page or 2 of analysis. None of these alterations are sufficient to sustain defendant's fair use claim. As an initial matter, U.S. law no longer protects abridgments as fair use, even in cases where the shortening involves, as Justice Story put it, real substantial condensation of the materials and intellectual labor and judgment bestowed thereon, and not merely the facile use of scissors. Instead, under the Copyright Act, abridgments are generally considered to be derivative works, and the right to prepare them is reserved exclusively to the copyright holder. See the Twin Peaks case. With respect to modifying the novels for a younger audience, the mere removal of adult themes does not meaningfully recast the work any more than an airline's editing of R-rated films so that they can be shown to children on a flight absolve the airline from paying a royalty. As Judge Laval puts it, the question is whether the work produces new insights and understandings. Here, defendants expurgated... I have never seen this word before. Expurgated guides are a vehicle for conveying to children the novel's original stories and insights. Indeed, it is quite clear that defendants' guides seek to fairly represent the original work of authorship. Defendants admit as such. Finally, there is the question of whether defendants' guides qualify as educational criticism or commentary. Works of criticism and commentary provide the sort of new insights and understandings that are the sine qua non of transformative use. Defendants suggest that their guides should be considered commentary. As evidence, defendants point to the few pages of analysis, but tacking on these few pages does not provide a safe harbor for an otherwise infringing work. The law is clear that, to be considered transformative criticism, the aspects of a work that reproduce another's protected expression must be in service of commentary on that work. Indeed, it is not enough for part of a work to have transformative purpose. Courts must also consider whether the work does so, transforms, to an insignificant or substantial extent. If a defendant's work describes the plot of a copyrighted work briefly in order to add significant comment about the author's plotting technique, then it's protected fair use. But if a defendant copies more than is necessary to facilitate comment or criticism, then it will not be protected. Here, defendants' story summaries do not recount plaintiffs' novels in the service of literary analysis. They provide literary analysis in the service of trying to make the guides qualify for fair use. Indeed, the defendants admitted this in open court when their counsel explained that Colting and Medina went to great lengths to achieve fair use protection. The very fact that we have these sections in the books, the main characters and keywords and analysis section, these things were all done to make these books fair use, at least in the mind of the defendants. Fair use, however, is not a jacket to be worn over an otherwise infringing outfit. One cannot add a bit of commentary to convert an unauthorized derivative work into protectable expression. Thus, defendants' guides do not transform plaintiffs' novels in a legally cognizable way. For this reason, and because defendants' guides are of a commercial nature, the first factor strongly favors plaintiffs. The second factor of a fair use inquiry is the nature of the copyrighted work. Expressly creative works tend to receive more robust copyright protection than news broadcasts or nonfiction publications. In this case, plaintiffs' novels are precisely the sort of creative works, thus the second factor favors plaintiffs. Amount and substantiality. The third factor, the amount and substantiality of the portion of the copyrighted work used, must be examined in context. This is not, as defendants conceive of it, a question of bare percentages. Instead, it turns on whether the extent of the copying is consistent with or more than necessary to further the purpose and character of the use. In cases of parody journalism and criticism, fair use doctrine allows for more of a copyrighted work to be copied where the purpose is less transformative. The question here is whether and to what extent defendants' copying was necessary to serve some transformative purpose. The answer is clear. Nearly all of defendants' guides are devoted to telling plaintiffs' copyrighted stories, with only 2 pages devoting to analyze them. Thus, the third factor favors plaintiffs. Effect on the use on the potential market. The fourth factor is the effect of the use on the potential market or the value of the copyrighted work. Under current law, plaintiffs need not show that their novels have suffered an actual drop in sales. To negate fair use, one need only show that if the challenged use should become widespread, it would adversely affect the potential market for the copyrighted work. And because the licensing of derivatives is an important economic incentive to the creation of the originals, this analysis must not only consider the effect on the defendant's guides upon the market for plaintiff's original, but also the effect of the guides on the potential market for derivative works. Defendants make two arguments in support of their contention that the fourth factor weighs in their favor. First, they argue that their guides do not affect the market for plaintiff's novels. To pretend that any consumer would go to a bookstore seeking one of the great American classics and instead choose to purchase an illustrated children's book defies belief. But it is defendants' burden to show that their works will not adversely affect either the market for the originals or for the derivative works. Both sides agree that there is an established market for derivative works as children versions of adult novels, and that publishers often choose to license their works to exploit that market. Indeed, plaintiffs provide many examples for the record of publishers exploiting this market in this way. Defendants also argue that plaintiffs have never created, marketed, or licensed any work that remotely resembles defendants' works. But even if this were true, it would not be enough for defendants to show that plaintiffs have not exploited a derivative market. It suffices as a matter of law that plaintiffs might change their mind. If the defendant's work adversely affects the value of any of the rights in copyright in the copyrighted work, the use is not fair. Thus, children's books fall into a market niche that plaintiff would in general develop or license, the fourth factor favors plaintiffs. The court will also take into consideration other factors that might bear on the question of fair use. Among these is whether, as defendant argues, their works should be protected because otherwise the constitutional purpose of copyright law would be frustrated. The constitutional purpose is to protect the progress of science and useful arts. As defendants point out, copyright law is designed to motivate the creative activity of authors. This monopoly created by copyright rewards the individual author to benefit the public. Thus, defendants ask the court to assess the interests of the public in the context of the facts of the specific case. Plaintiffs do not include authors, but the heirs, trusts, and estates of authors. Plaintiffs have not published illustrated children's books based on their novels and appear to have no intention of doing so. Thus, according to defendants, plaintiffs explicitly seek to stifle the creation of new works, and their sole interest in this case is not to preserve their own works or their ability to license their works, but instead to prevent the creation of new works. Plaintiffs' motives, they contend, do not satisfy the constitutional imperative that the limited monopoly granted to authors be exercised in such a way to promote the progress of science and the useful arts. However, the court cannot apply one fair use analysis where copyright holders can show they plan to exploit their works to make derivative works, and another fair use analysis in a case where copyright holders have not exploited such rights for half a century or longer. Such an approach would be inconsistent with the Copyright Act. Congress did not provide a use-it-or-lose-it mechanism for copyright protection. Instead, Congress granted a package of rights to copyright holders, including their exclusive right to exploit derivative works, regardless of whether copyright holders ever intended to exploit these derivative works. Indeed, the fact that any given author has decided not to exploit certain rights does not mean that others gain the right to exploit them, at least not until after the statutory copyright period, author's life plus 70 years. Implicit in defendants' argument, then, is a contention that the Copyright Act itself is unconstitutional. In sum, given the clearly infringing nature of defendants' guides and the fact that the guides are unauthorized derivative works that do not primarily critique or parody, but rather reproduce, albeit in different form, plaintiffs' original works of authorship, no reasonable trier of fact could find for defendants in this case. The court, therefore, grants summary judgment and orders the clerk to close the case, or close the motions, and grants all 9 counts of infringement, and rejects the affirmative defenses of fair use. Very interesting. So that's what it looks like when you try to use fair use to cover up otherwise infringing activity. What do we think of that? That was a very interesting case and well written by Judge Rakoff. Very interesting to read. It just sort of flowed. That's another reason why Judge Rakoff is a federal judge, is he knows what the heck he's doing. Brandon, do we have any questions about that?
Not really, no.
Okay. I need to take 30 seconds to hit the restroom, so I'm going to hit an ad here and run to the boys' room, and I'll be right back.
Awesome.
See if that works.
Hello, ad blockers and Canadians. I'm Brandon. How are you doing today? I just wanted to let you know that you're all awesome. Also, everybody who's watching who hasn't already, we really, 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 really want you on Discord. Discord is great. It lets you communicate with Leonard, send him stuff if you want to, communicate with me. We have a huge gaming community on Discord. All kinds of stuff. We have a bot specially coded for the purposes of gaming and setting up gaming channels and stuff like that. So if you haven't already, please check out Discord. We have a link in the description. It's really easy to get signed up. You don't even have to sign up. You can log in without signing up. So check it out. I was talking to the Canadians and the ad blockers.
Okay, it looks like it said the ad insertion was successful, but everybody's telling me there's no ad. So whatever. It was. I'm back. I'm assuming I'm back, and all of you can see me. So I guess yell at me if you can hear me, but you can't see me. I don't know. I don't even know how this works. So that's very interesting. Did we get any questions on that, Brandon, or should I move on to our final stories?
I don't think we have any questions. If we do, they'll be after. So.
Okay, I'm going to skip over but go back to the opioid thing. And we're going to go here first. So this is the Nintendo Creators Program page. You may remember we made a video about this back in April or May or something like that, about how the Nintendo Creators Program is something you have to sign up for if you want to be able to live stream or produce videos with Nintendo content. You can only do this on YouTube. They'll take you down anywhere else. They'll take you down if you aren't signed up for this, and you should dedicate a channel to this because they're going to take your whole channel's revenue, or at least a part of your whole channel's revenue, even if only some videos are Nintendo videos. Or you can sign up for like one video at a time, I think. So I already had some concerns about this program, but now they have added some language here that some people have noticed, and actually a notice did go out to everybody. But can I do a live broadcast featuring Nintendo games on the channel that is properly registered with the Nintendo Creators Program? No. You can no longer stream Nintendo games live. Live streaming falls outside of the scope of the Nintendo Creators Program. It says here on YouTube, but YouTube is the only place where it was originally authorized, so it's outside of the scope for everybody. You cannot broadcast content live on YouTube from the account that you have registered to the Nintendo Creators Program. Now, are some people going to do that and get away with it? Probably, but the point is if you don't want strikes, if you don't want a problem with Nintendo, you can no longer live stream any Nintendo games whatsoever. I was looking into this because I recently picked up Super Mario Odyssey, and I'm having a great time with it. It's honestly one of the greatest games of all time. It's right up there with Super Mario N64 and Super Mario Sunshine. It's got a lot of callbacks, but they aren't like shoved in your face, and it's got a great story, in Nintendo's story. But it's not like cutscenes and stuff. It's actual gameplay, and the gameplay is clever and fun and colorful, and I'm really having a good time with it. So the first thing I thought of is, wouldn't you guys like to see me playing Super Mario Odyssey on a live stream? And so the most that I've been able to come up with is this way. I figured out how to do it. I figured out that you can sit here and watch me with the sound off, play it on the back of my Switch. So how about that? You want to play some Super Mario Odyssey with me right now? What do you think? Here we go. We're playing some Super Mario Odyssey together. What do you think? Isn't this the best ever, Nintendo? Isn't this just great that I get to share this with my stream?
You're killing me, Leonard.
So Rolling Stone even picked this up. I mean, come on, Rolling Stone picked up the Nintendo's creator program. No longer allows live streaming. And I'm not going to try and usurp their market. You guys can go read the Rolling Stone article for yourselves. You guys search for Rolling Stone Nintendo Creators Program. Jeez, I'm just at a loss, guys. Why Nintendo continues to like go backwards in the content realm? I can understand a company wanting to be super concerned that someone's going to make Nintendo related content that is arguably allowed because it's a fair use and or Nintendo gave permission or something, and that it somehow is going to make people think negative things about Nintendo, like someone's going to make a sexual video out of a Nintendo something or other. They can do all of this in a different way. We've seen Persona 5 try to do it with live streaming guidelines. Nintendo can issue live streaming guidelines and say that if we find it to be particularly offensive, even subjectively offensive, that they would have the right to take it down. So I also understand that there would be an uproar from even that kind of restriction, but that would be better than no live streaming whatsoever, right? So, yeah, I don't even know what that's all about. But that's the status of things today. Yes. Don't. That's the microphone. People can hear that. You're now moving the microphone. No, don't stop it.
I'm leaving this in on the video.
So what do we think of the Nintendo Creators Program? And yes, it probably has something to do with Nintendo being in Japan and Japan having a different kind of copyright law. They're supposed to observe fair use and copyright law that is internationally recognized. So they're supposed to be observing some kind of fair use or copyright law, but they currently are not really doing that. So this is a very interesting situation. I'm not sure why they're being so difficult about this, but you know, it's Nintendo. I can't complain that their games aren't good, so I don't know. And then let me see if we can do this transition with a dog on my lap. Oh, honey, what did you eat? That smells awful. My dog is farting while I'm on my live stream, and he's on my lap. And you know, he's a golden, so he's got all this hair, so they're silent too. You just smell them. You don't even hear them. Okay, so another story that recently has been in the news, the President of the United States, and no, we're not going into the President and his political views or anything, but the President has declared a state of emergency on opioid abuse. Now, yes, of all the stories, I kind of expect this one to get demonetized, so I'm not going to be terribly surprised if a story on opioid abuse gets demonetized. But what has happened is that there are some charges being filed in the District of Massachusetts against Insys, a pharmaceutical company. The founder, I'm not sure if it's Michael Babich or one of these other people, but the founder of Insys has been charged with racketeering in a scheme to sell and provide opioids to people who don't need them through doctors and pharmacies and all their normal channels. And this is 79 pages long, and we are 2 hours into a live stream, so I'm probably not going to read this in its entirety. But I wanted you to be aware, because this is a fun one. Maybe I'll do a bridge. Maybe I'll do a kinder guide of this indictment, since it's 80 pages long, explaining what exactly they were charged with and why, and etc. They basically are being charged with selling fentanyl spray, which is an extremely powerful opioid, way more powerful than heroin. Some of the major overdose problems that we're having in some communities these days are because of fentanyl and other opioids as well. But fentanyl itself is people don't know how powerful it is, don't know how to properly dose themselves with it, and so they end up overdosing. And since they're using it illegally, they're not doing this, in a way that they feel comfortable going to the doctor to make sure they're doing it right. They're doing it illegally, so they're doing it at their homes or whatever, or worse, and they're finding themselves in an overdose situation, and it's happening at an alarming rate. I do believe the numbers are correct that it's worse than current gun homicides, gun suicides, and car accidents combined. I believe the problem is one of the larger problems in the world. Well, at least the larger problems in our country right now. So the fact that these pharmaceutical companies, or at least this one pharmaceutical company, prescribed these illegally in order for users to get the drugs through legal channels, and the pharmaceutical company could profit from it, and so they've all been charged with this. They conspired with defendants and other persons and entities to engage in the various criminal activities described below. Summary of the allegations. The company launched the fentanyl spray in March of 2012, a powerful and dangerous opioid approved to treat breakthrough cancer pain, into a small national market that had a lot of competitors. Because of the potential dangers posed by the misuse of opioids, fentanyl is designated as Schedule II, and products containing fentanyl are tightly controlled. In addition to being tightly controlled, it's expensive. Following the launch of the spray in 2012, the defendants quickly grew dissatisfied with the success of the drug. They sought to devise and foster a scheme to profit by using bribes and fraud to cause the illicit distribution of fentanyl spray. They sought to bribe practitioners to prescribe the spray outside of the usual course of their professional practice. They used bribes and kickbacks to cause practitioners to issue new prescriptions, as well as increase dosages, volumes, and existing prescriptions. The bribes and kickback took forms of speaker fees, honoraria, food and entertainment, administrative support, and fees paid to co-conspirator pharmacies. They were reluctant to approve payment for a drug when it was prescribed for patients without cancer. The potential for profits generated by the bribes could not be fully realized until insurers authorized payment. Accordingly, together with the co-conspirators, they sought to mislead and defraud insurers and the agents of insurers into authorizing payments for the fentanyl spray. So not only did they bribe doctors, they misled insurers. From a call center at corporate headquarters, co-conspirators defrauded insurers, caused illicit distribution of fentanyl, disguised the identity and location of their employer, misrepresented patient diagnoses, the type of pain being treated, and the patient's course of treatment with other medications, bribing practitioners and pharmacies, etc., etc., etc. I'm going to stop that there because that goes on for 70 more pages. Also, the dog is done, so you know that's the end of that. And we'll try to level this real quick. I hadn't planned for that. So what do we think of that? That is a very interesting case that I think I'm going to cover a little bit longer on a finished, recorded, edited video because of its extreme length. So what do we think of that? Yes, I couldn't also help but notice that THC and marijuana are still Schedule 1, but in the interest of keeping my videos monetized, I'm not going to go any further into that. Please submit your questions to Brandon via the link that he's going to post into the chat. And Brandon, let me know when you have some questions that people would like to have answered. I think that's the end of our stream. That's the final. And I did it in 2 hours. I did it. I got through all like 8 stories. I'm amazing. I'm humble.
Give me just a sec.
Yes, please take your time.
I do have questions, but I want to make sure I get this right.
Yeah. Cool. I see what you're doing with the highlights. I really appreciate that.
Yeah, we'll have.
And what we'll do is we'll schedule these to release throughout the week, and they won't be my only videos this week. I got the bug. I'm finally free from all that other stuff that I've been doing, and I was really trying hard to get more than one video out last week, but it was a very busy week too. But this week is not busy. This week is not. I'm going to have all the time to do all the videos this week, and I'm try to get one video out a day is the goal for November, but we'll see. That's only a personal goal. I'm not hoping to have all of you upset with me if I don't do that. So it's just a personal goal that I'm setting. Yes, ex animus, my Five Nights at Freddy's hat is wearing a hat as well. That's correct. I don't know if it's a fez, but it's definitely a small hat that Freddy Fazbear wears. Oh, I think there's a new one out, right? I've got to go watch Markiplier play the new Five Nights at Freddy's and maybe even buy the game just out of support to the developer, even though I don't really like to play them because they're kind of scary and I'm a coward.
All right, I'm good now. I can ask you some questions.
Go for it.
Paul Cuts UK once again asks, how does a person using a pseudonym affect their rights to privacy and thus giving them grounds for a DMCA takedown of a video that their online persona is in?
Well, most of the time when you provide your information for a DMCA takedown, you can provide a pseudonym or you can provide an agent or a representative. It just has to be accurate. It has to be true. You can't lie. So definitely, if you have a pseudonym and you don't want to reveal your real information, go through a representative. Find an attorney. Just to send a DMCA notice, I can't imagine an attorney is going to charge an enormous amount of money. So see if you can find somebody to do it for you and use and as your representative and use their name and address. You would probably be able to use your pseudonym as the owner of the copyright. And I would understand why if I was a judge. But I would also, as an attorney, want to look into that further before we send a DMCA notice with a pseudonym on it. I don't think it's a problem, but I don't know off the top of my head. I haven't had to send any, except for the one to a certain defendant that we all know and love so much. Thank you, Brom M, for the Canadian $20. Finally caught a live stream. Thank you for doing what you do. I appreciate that. And I also need to reload this.
Next question is from Elephants in the Forest. Cool name. Have we seen any significant income from YouTube Red, and has the adpocalypse affected that income?
I'm sorry, I was reading something else. What was that?
Apologies. Elephants in the Forest asks, have we seen any significant income from YouTube Red, and has the adpocalypse affected that income?
YouTube Red is decent. I forget the percentages, but it makes up a significant percentage of my monthly YouTube income. So yes, I do appreciate the YouTube Red. Those of you who use that, that's actually way easier to work with than the adpocalypse because there isn't a demonetization for YouTube Red, I don't think. I think we're still monetized as YouTube Red when the ad demonetization happens. So that part is not affected.
So I actually can explain this in a little more depth if you'd like. Only if you'd like. So YouTube Red makes up...
We lost
Sorry,
you.
I had a bit of an issue there. YouTube Red makes up about 20% of our income, probably. And the way it works is, a lot of people think that it gives the creators that you watch income. Unfortunately, that's not how it works. If that was how it works, that would be wonderful because we probably make a lot more money on YouTube Red. The way it works is that all of the YouTube Red money goes into a pool for all of the partnered users on YouTube, and then you get a percentage of the pool based on how much watch time you have that is monetized. So
yes,
basically we get like whatever 0.00001 of the pool because we have a certain amount of watch time, which it ends up being a pretty significant amount of money. It's not a big deal. that it's so small because, I mean, there's so many creators. So, but that's how the YouTube Red system works. And yeah, it is a significant amount. It's almost like a fifth of our income comes from that. So
Cool. More questions?
I do have more questions. Question from Seaweed B. If you, Leonard, were to be sued by someone for something relating to copyright, would you represent yourself? Would a judge look down on that, or would it be considered perfectly normal?
It would depend on what I was sued for. If I was sued for something simple, I'd probably defend myself. If it was something complicated or something that was personally emotional or took a lot of time away from my other work, then I would probably hire somebody. Whether or not I could afford them, we'll see, because I certainly can't afford a $25,000 attorney either. So it would be an adventure. I'd probably have to start by representing myself, or maybe I'd work with someone and I would pay them something, but less than a total representation fee, and I would do some of the work too, or something. That's probably the way I'd work it out.
The second part of the question was, would the judge treat you any differently for representing yourself?
Maybe sometimes judges are concerned about pro se litigants, but so, for example, we've seen in the Imagos case that the judge did not like my attempts to default Alex, even though Alex filed her answer late, because he did not favor treating pro se litigants that way. I'm not sure if that standard would apply to a lawyer who is a pro se litigant. I'm not sure I would get the same leeway. So I don't know if they would look down on it, but I definitely wouldn't get the extra help that judges often give to pro se litigants.
Cool. Ultra Force, basically. So the children's book case that you went over, it was 31 minutes long. It was very wordy. Would you be willing to give a very short summary of what happened there?
Sure. The children's book case was basically a case where four major publishers and four major books, 2001: A Space Odyssey, Breakfast at Tiffany's, and Old Man in the Sea, and one other one I forgot already. A separate company without permission made condensed abridged versions that contained some illustrations and some analysis and some quiz questions and stuff, kind of like a Cliff Notes version. I didn't see it myself, so I couldn't tell you it was exactly like Cliff Notes, but the judge went through all the reasons why that is not a fair use. The condensed version does not it usurps the market while not transforming into a new productive work. Instead, it kind of grabs the market from the existing author. The market for either a condensed or abridged or children's version is just completely usurped by this children's guide. So they have to pay a license fee or not at all, not do the thing at all. So the judge went through all of that, and so we have a new fair use ruling that says that, juxtaposed with the H3H3 case where the criticism and commentary made it a fair use, here in the children's book condensed version case, a abridgment or whatever does not automatically create a fair use, and you cannot wear, as in like wear like a piece of clothing, you cannot wear a criticism and commentary jacket over top of an infringement to cover up the infringement. So here they had copied dozens of pages, or rather they had reproduced dozens of pages of material directly from the original books, while trying to remove adult themes and only adding a page or two of commentary and questions at the very end. And the judge said that that wasn't enough. That did not make it a fair use. Not only did it not make it a fair use, but it looked like, via testimony and evidence and even a statement by the defendant's attorney, that they had only done that extra stuff to get around the copyright infringement and make it a fair use. So instead of starting from a perspective of we want to take this work of authorship and turn it into something new that does, that we can use, instead they were like, hey, we want to copy this book and we think we can do this as long as we just touch on these fair use factors. And the judge didn't like that. The judge did not agree that you should target creative works as, let me see how little I can do to this to get it to become a fair use, whereas rather a sincere effort to create a genuinely new copyrighted work that adds to the original and does not usurp the market and complies with the other two fair use factors. That looks a little more genuine and sincere than simply putting a couple pages at the end of an abridged novel or abridged classic edition or abridged edition of a classic novel in order to suddenly make it a fair use. So the judge figured that out and saw through that. Let me catch up with some of the donations. Mike Weber, $5. Could someone quickly summarize the Nintendo matter for me? Sure, the Nintendo Creators Program no longer allows you to live stream, and that's it. That's their policy. They changed it. Fine, goodbye, you're done. Don't live stream Nintendo anymore. Have a nice day. That's it. They changed their policy. I don't like it, but they own Nintendo, and so they can decide that they don't want you to live stream. So unless someone's going to go to court and win a case somehow saying that live streaming is either a fair use or somehow also authorized, I don't see it happening. I think Nintendo's got this one. Sorry. Mary Jones, thank you for the 500 yen. I have seen BS. That's pretty big BS. You didn't swear. Here's to you not getting demonetized. Thank you. I am also frustrated. Krish Yadalam gives 40 of a currency I don't recognize. I really appreciate that. Thank you very much. And I will learn now today what that currency symbol means, because someone's going to point that out to me. Thank you very much for that,
I'll find
too.
it for you.
Brom M gives Canadian 20. Finally caught the live stream. Thank you. Jesper N gives Danish kroner 20. Did you make the copyright for creators video yet? No, I have not released that. I swear it will be this week. I know I keep saying that. I'm so sorry. I feel so bad. It takes a long time to edit, and I make mountains out of molehills, and I really have to just force myself to sit down for a couple hours and finish the darn thing. It is mostly, I'd say, halfway finished with the actual editing process. I want to finish the editing, and I want to put a little bit of a treatment on it, so that it's not just a talking head video, but also has lots of exhibits and visuals and is exciting. And so I really think it'll be worth it. The long wait will be worth it, and I don't mean to make the mountain out of the molehill. So I apologize to everyone, including New Sensei, for it being late. But it will be good, and it will be worth it, I swear. Lord Dissy, thank you for the $20. I don't know what you're slurping, but you have slurped officially. So thank you for your $20 and your slurp.
That symbol denotes Indian rupees, by the way.
Indian rupees, very cool. I think that's one of the first times I've received Indian rupees. I think I might have seen that before, and I really appreciate it. Thank you very much for your donation. That said, are there any more questions, Brandon?
We have 2 more questions that I've whitelisted, and then we can maybe think about wrapping up.
Okay.
Next up is Elephants in the Forest asking, who owns the copyright on court documents?
The actual, so things written by the court and pleadings written by the parties and such, those are not subject to copyright in the traditional sense. They are mostly uncopyrighted, and they are mostly public domain. What you have to watch out for is if anything was like an exhibit or maybe testimony, but definitely evidence and discovery and things could find evidence that contains a licensed copyrighted material. Like, for example, parts of these books, that we just went over, to Breakfast at Tiffany's, 2001: A Space Odyssey, Old Man and Sea. Parts of these books would be in the exhibits. So while I can read the parts of the books as part of the live stream or part of the show or whatever, while making commentary and education and all that, what I could not do would be, say, use Exhibit A as like, hey, look, somebody put the entire work as Exhibit A, I can republish that. No, you can't. Maybe you could get away with republishing the whole court case or the whole entry, but if you tried to say like, hey guys, here's a free copy of To Kill a Mockingbird because it got entered as an exhibit in a court case, no, I don't think you can get away with that.
That was actually a really good question.
Yeah.
Next, and our last question would be Torquio, I think. In regards to Nintendo, do you think there will come a time when Nintendo respects fair use? If so, what do you think has to happen in order for that to happen?
Well, Nintendo must respect fair use in each member country, members of the various treaties that observe copyright law. So while you might not be able to win a copyright case in Japan, Nintendo is subject to U.S. law when they are in the U.S. And if you're in the U.S., you're subject to U.S. law. So make a fair use video. You're going to have to make sure it's fair use, maybe even consult with an attorney, but make a fair use video, put it up on a channel. When Nintendo inevitably comes along and either takes it down or demonetizes it or something, you then can go to court, make your fair use argument, and if you win, you're the person. Your case was the one that set the precedent that Nintendo can't take down everybody, but only can take down things that aren't a fair use. In the past, I've said things that aren't a fair use are things like Let's Play videos. So your argument that playing Super Mario Odyssey is a fair use is going to have to be a really good one if all you're doing is playing. Even if you are adding criticism and commentary, you saw in today's live stream, or you can go back and watch the Judge Rakoff book publisher thing, you saw that not everything is a fair use. You can't just play the whole game and add a little bit of commentary and have it be a fair use. You have to use the minimum amount necessary to make your point and nothing more. So if you've used the whole game to make commentary and you didn't make what a judge is going to agree is commentary the whole time, then you're infringing. So you probably want to make something that clearly falls on the side of fair use, and then if Nintendo takes that down, you would have a court case, and even then, you'd have a court case that you get to pay for, that you get to do your own work on and everything. You have to advocate for your own court case with your own attorney and everything. None of it happens automatically. So while I'm certain that you could appeal to social media or crowdsourcing or whatever, crowdfunding to get some traction and help on that, it's going to be all you, buddy. So that's probably why it doesn't happen more often, because who wants to do that? Who wants to take the time out of their life? Unless they're really being damaged or they really have a lot of financial resources or other resources that they can get through these sorts of things, then I see why people don't file lawsuits more often and simply comply with Nintendo's demands. Also, thank you to Elephants in the Forest for your $3.14 Australian. I appreciate the pie. All right, are we out? Are we done?
Let's not.
Is that all the questions?
Oh yeah, that's all the questions. Yes, for sure.
And what were you saying then? Let's not
forget that we're doing a gaming after stream this time around.
We are going to do gaming on Twitch after this, and you already saw me head to the bathroom, so I can pretty much just switch right over. And what are we going to do? We're going to play some PUBG today, or what?
I think so. Yeah.
I know. I love Helleborn, but I also know that I love Helleborn, and not like you guys play it because I like it. But it's not always your favorite game, so. Let's play some of PUBG, which is a little bit more everybody's favorite game. You know what I mean? Also, thank you, Brandon, for doing all of the work clipping things from this live stream. As expected, yes. The guess what? The opioid story is already demonetized. This one makes sense. At least this one makes sense. I'm still going to request review, though, right?
Maybe. It's understandable.
Well, it doesn't hurt me, right? It doesn't hurt me to request review.
Definitely
right?
not. I did a view. I watched each video.
You know what? I wonder. I kind of do. Yeah, it doesn't hurt, right? Can we get some feedback from chat? Do we know if it hurts to request manual review of a video that does talk about drugs and stuff? Maybe I shouldn't try to request a manual review if this isn't a good idea.
Maybe.
What do we think?
It's a good point. I mean,
I'm okay with letting the opioid story go because it does talk about stuff that is arguably within or outside of YouTube's policy guidelines. They don't want you to talk about drugs too much.
it may be a cry wolf kind of situation where the bot will go, well, look at this one. He didn't get it, So who knows?
Yeah. We did talk about it respectfully. It was about a court case. It was educational. So we'll try it. I hit manual review.
So yeah, everybody, I'm posting the link in the chat. Make sure you join us for a gaming after stream if you're interested. Also join Discord if you want to stay updated and contact Leonard and myself and our moderators and our wonderful community. Was there anything else we missed? Doggos?
No, I think, we can get a doggo or two in here while I'm doing my out. And you know what? I'll put the music back on. We have some fun Halloween music from Epidemic Sound. I think you can even try it out yourselves if you really wanted to by simply going to epidemicsound.com and clicking on the Happy Halloween album. I don't know if you can download it or legally play it on your streams without paying their licensing fee, but you can definitely hear it. So playing that now. Hopefully you can all hear that.
Jinzo asks for an H3H3 update.
I love you, Jinzo. Thank you for moderating today, Jinzo.
Yeah, big shout out to Jinzo today. I wasn't able to do it myself.
And a shout out to all of my Patreon supporters who are helping me through this adpocalypse by giving me their hard-earned money, which I really appreciate. You guys have made this channel directly possible, is basically what that's about. And where we go from here just depends on how fast we can all grow. And that I'm not saying that you could give me $1 million and I'd be able to grow 1,000,000 times. I just mean that as we grow slowly there too. This is great, and I'm really appreciating this. So thank you all for that. Especially thank you to those of you who are contributing at the $50 plus level. Joshua Meinzinger, John Steele, John Cripps, Nate Beck, Lydia Collinson, and Westin Lohne are currently supporting in October for the $50 level. It's got to be over 100 of you contributing at the $5 level now. There are so many of you that I really can't list you all manually, by voice, on a stream. So I've put you all in the description below, and you also get to scroll on the LED panel behind me, which also reminds me on a daily basis of how many of you there are that contribute and support the channel. And there are probably another 100 plus or so who are contributing not at a publicly recognized level. That's a wrong way of saying it, because some people do contribute more than the $5 or $10 and they don't want to be recognized because they're private people. So thank you to everyone who is contributing, even if you don't want to be publicly recognized. I really appreciate all of your contributions, your hard work, and all that. You're helping create this, make this channel possible, and help it grow. You've seen what we're able to do. We're getting better. Every stream's getting a little better, and now we're even able to clip the things, and we're gonna put out the parts of the videos that people missed. So this is really cool. This is a really awesome experiment. I love you all, and it's turning into more than an experiment, isn't it?
For sure.
So thank you all for joining me today. I'm going to mute my line and go grab a dog or two and see what we can do. And then I'll see you all over on Twitch. And we'll play some PUBG on Twitch in about 5-10 minutes at the most. Okay? Love you all. See you soon. I'm Leonard French, your favorite copyright attorney, and I'll see you in several new videos this week. I promise. Scout's Honor. Yes, I have a broken finger. Scout's Honor. I promise I will release several videos this week, and we'll see what happens with the demonetization there as well. Those we're gonna wait to release until after the demonetization issue stops. So, anyway, thank you all. I'm Leonard French, your favorite copyright attorney, and I will see you in my next video. Oh wait, dogs. Hey, dogs. think he was asleep. I think they want to go out, so I'm going to take the stream out as well and bid you all a good Sunday/Monday, and I will see you in my next video. I'm getting bumped again, so love you all. I'm going to stop the stream now, and I'll see you later. Bye.